Hi guys, I hope I'm audible. Okay. Good evening, everyone, and a very warm welcome. Today, I'm your host. I'm Girik, and I think we all are very excited to be here because we are like this is one of the topic that we're going to cover today is one of the practically the most important topic for anyone in the clinical practice, medical jurisprudence, and the medical legal practice in India. As tonight's theme quite fondly reminds us, good documentation protects both the patient as well as the doctor, right? So this is exactly what we are gonna learn in this session as well. This session is brought to you by the Games IRC, which is the International Relations Council for the Global Association of Indian Medical Students. Just one small housekeeping note. Please keep your mics on mute, and if you have any questions or any queries, you can drop them in the chat box, and someone from our team will be there to assist you. And if you have any questions for our speakers as well, you can drop them in the chat box, and we'll get to them at the end. Without further ado, I would like to introduce our speakers. Today we have two exceptional speakers with us, and I'll introduce them as they come up. So yeah. Our very first speaker is someone whose credentials spans chemistry, law, and healthcare administration. She holds an MSc in chemistry. She holds an MSc in chemistry and LLB and LLM in corporate law. She has a PG diploma in hospital administration from Apollo Delhi, a healthcare law specialization from the University of Pennsylvania, United States, and serves as a senior advocate at the Supreme Court of India and the High Court of Uttarakhand. She will be covering documentation and medical legal case along with ethical and legal challenges in the modern practice. Please welcome Advocate Seema Dhingra Bakshi, ma'am.
Thank you so much. Thank you so much, Giri, for such a wonderful intro and the welcome. I'm so blessed to have you all in my life. And I welcome all the participants too. So Giri, I'll just take a while before
Sure,
I
ma'am,
start.
absolutely.
Yeah. We are having bad weather actually over here.
Oh, no worries, ma'am. You can take your time. That's absolutely okay.
Oh, that's fine. Thank you, Giri. So this is about today's topic. Like I'm so honored to be among with you guys, and we'll discuss about clinical jurisprudence and medical law ethics. Right. Let's start with first of all, there is a major legal shift has been happening in recent past in 2023. So old transition. Wait, am I audible?
Yes, ma'am, you're audible.
I don't know how to do it. You're saying it unmuted. Yeah, Kirik, I'm so sorry.
No worries, ma'am.
There was some technical glitch. Can you, am I audible now
Yes, ma'am,
perfectly?
yes, ma'am, you're audible.
My screen is visible to all of you?
Yes, ma'am, it's visible.
Yeah, earlier, I guess there was some technical glitch. I could not make it, and sincere apologies for that. Let's
Yes,
restart
ma'am.
this. Once again, thank you for your keeping so patient. And let's start with the clinical jurisprudence and medical law ethics without wasting any further time. So there is a major legal shift has been happening in 2023 and all old transition, this transition has replaced the old colonial criminal codes to the new one. IPC, which was earlier Indian Penal Code, that has been CRPC has been replaced by BNSS. Indian Evidence Act has been replaced by BSA. The purpose to narrate this thing today is that this we have to make it operational, and we have to be ourselves familiarized with all these exact legal sections to avoid any error, any in official finding, or any further documentation, and to stay away from any kind of jeopardies in the future, right? Now there is curriculum review. I'll be moving very fast. Record and consent. Consent will be taken over by my co-speaker, learned co-speaker, and she's very good with that. Ki how to maintain, how to do the consent. And MLC and privacy is again medico-legal cases under BNSS, DPDD policy. Lots of policies are there. Social media constraints are there. Then risk mitigation. I'll cover this. Let's go ahead now. There is. Let's start with some case study kind of interactive session. So here it is, like a victim, a patient of a hit and run is brought to the ER. This is purely emergency room dilemma, brought to the ER with active atrial bleeding. The police officer present insists that the doctor registered the MLC first, do the documentation first, kept on insisting he or she, before starting the therapy. Now, the core legal questions arises. Does medical treatment precedes legal registration? Is anyone there to answer for that? Does medical treatment precede legal registration? The another one is that what are the legal protections if the patient dies during stabilization before police registry? Couple of time it does happen. You go for in a haste, like you are feeling some chest discomfort, some kind of pain is there. You rush to the hospital, you rush to the ER while getting monitored for the vitals itself, for BP and everything. The patient collapses due to cardiac arrest or something. So who will be held responsible for that? So there is a clear-cut Supreme Court ruling. Saving human life takes absolute priority. The the concerned doctor has absolute duty to save and stabilize the patient first before doing any documentation or any paperwork. This is mandatory action protocol. We have to stop bleeding. We have to stabilize first. If we have to give the oxygen, we have to supply the oxygen to the concerned, whatever it is needed. As per the medical, we have to do the first. Medico-legal legislation must wait until active emergency treatment is secure and the patient has been stabilized in the ER room. So let's move ahead with the criminal code. So a lot of changes are there. One basic, we talk about lot of negligence, medical negligence. We have seen many cases. We have read on the newspapers and channels and media, and we came to throw about the medical negligence cases. Earlier, this was governed by Section 304A of IPC, Indian Penal Code, and now this is 1061 of BNS. There is a landmark judgment which has been described, which described clearly this section. This is Jacob and Matthew case versus State of Punjab. The case is somewhere of August 2005. In this case, what happens exactly? A patient who was feeling discomfort and breathing issues went to the nearest hospital with the same complaint with his son and his brother, younger brother. After reaching to the ER, they were seeking because they were in emergency. He was breathless. He was not able to breathe. Requested to call the concerning medical staff, hospital authority, or the doctor. They waited in the ER for approximately 25 minutes. After 25 minutes, the nursing staff arrived. Then the doctor, Joseph and Matthew, Joseph, they arrived. They ordered the oxygen. The oxygen supply is needed to the patient. What they do, they immediately, the nursing staff put the oxygen mask on the patient just to get the patient stabilized. Then certainly they realized there is no oxygen in the cylinder. They rushed, they checked into the entire hospital premises. There was no oxygen slip. Sadly, there was no oxygen cylinder was available in the entire hospital premises. Within 7 minutes, that patient left this world and patient died. Now, is this a case of pure negligence? the son and the brother of the deceased filed a suit before the court, and this has been discussed. How come to the doctor should held criminal liable for the such act? Now there is one word in a legal term which is called mens rea. There should be intent to kill. Here in this scenario, doctor was not, the all medical staff was not having any intention to kill the patient. Their pure intention was just to safeguard, to save that patient. Somehow they failed that. So there was no recklessness, there was no gross negligence. So the doctor cannot be proceeded or prosecuted under 106 of BNS. So general negligence, if does happen, then the penalty and imprisonment will be up to 5 years. Any RMP during any procedure, any intervention, maybe surgical or somewhere else, the punishment has been capped up to 2 years of fine, not beyond that. I guess everybody understood this criminal code because it's the basic and one has to understand that. Now let's come to the next part, clinical documentation and record retention. There are 4 pillars for the clinical documentation. And I would like to tell everybody the strongest defense inside any courtroom is not the wonderful argument and the brilliant argument. Then the strong defense is the records and the documentation produced before the court or the bench. So medical records represents the first line of defense in the legal cross-examination or a best defense. So effective notes must fulfill the ABCD rule. ABCD rule is just a rule, very simple one. It should be accurate one. Whatever you're writing, it should be very precise, vitals or patient name, detail, age, time, and everything. Chronology should be very precise. It should be brief and clear. And record, we have to record all the things, observations immediately because there is a memory gap. We tend to forget. So there are high chances to miss anything. And is there is any red flags or warning signs or negative findings, and then we have to mention that very clearly, and we have a right to refuse of care also. We can say no also. Doctor has a right to say no also under certain circumstances. The core exam will come to the golden legal doctrine is there regarding this documentation itself. In clinical litigation, what is not recorded on a patient chart simply was never done in the eyes of the law. So documentation and records are actually the prime importance. This has been said by the Honorable Court of India when it comes to the jurisprudence liability, medical jurisprudence liability. Now, the critical fact is that more than 70% consumer court cases, or maybe you can say civil litigation against the medicos, are due to not due to clinical negligence. It is only attributed to missing, incomplete, or subsequent modification of the records rather than diagnostic error. Sometimes we try to modify or append or amend that, which we are not supposed to do in any record. Now there are some regulations regarding the how long we should keep the record of which patient and for how long, for how long period we have to keep it there. So the standard has been maintained. It is for 3 years as per the NMC guidelines or regulations. We have to maintain the records post discharge of the patient up to 3 years. There is some exception, which are pediatric and MLC. For pediatric, we have to keep the records until the child attains the maturity, that is 18 years plus 3 years additional is there. When it is MLC, medico-legal cases, we have to keep it archived indefinite time, and you can say until the disposal of the case before the Honorable Court of the jurisdiction. Now, this is the prescription part. I assume that we have a lot of medicos over there, so there is no need to explain about this prescription part. It's very simple about the doctor detail, patient identity, drug generic name. Yeah, we have to prescribe generic first, then the other one, precise doses, maybe it's OD. BD or whatever it may be, frequency and duration, refill warning and reviews and follow-ups and instructions. This is all the part of prescription. I think everybody is aware of there. Now, there is again one scenario, and we should discuss it, and I hope somebody will assist me that and in answering that. Now, there is one scenario, a doctor scribbles a prescription rapidly. Sometimes, we always hear that doctor's handwriting is always illegible. We cannot read it very clearly, though we are supposed to. So the doctor scribbled that prescription. The pharmacist misread a sound-alike drug, and he dispensed a highly potent anti-arrhythmic instead of standard antihistamine. Now, what happens that the patient suffers a cardiac event, sadly. Now comes to the legal liability allocation. What happens now? Is the doctor solely responsible? Is anyone? Or does the pharmacist so share a liability? Is anyone?
We are getting some responses in the chat box that the new rules mandate capital letters for prescription. So yes, the doctor is responsible.
And what about the pharmacist?
We are getting mixed responses that both are at fault as well.
Yes, you are amazing. So wonderful, Greg. Thank you so much. Yes, both are having joint and severe liability. Both will be held accountable and criminal liable for that. So just to avoid this thing, EHR should be followed now, because IT has been advanced, everything has been, we have DICOMs, we have PACs, we have so many things as the right. So we should go with the electronic type prescription just to avoid such kind of situation. You're just great. Thank you. Now discharge protocol. Now patient has been treated, well treated, everything has been, it's time to discharge. So discharge, here is a case study. If we see regarding the discharge, what happens? Now, there is a hit and run case. 2023, Manoj versus Dr. Shukla, UP Lucknow case is there, hit and run. The patient was hit by a car. He was in the car and hit by a truck. And his right hand, right leg, chest, and pelvis were broken, badly injured, and brought to the hospital by a police officer. When he brought to the hospital, nearest hospital, after doing certain images, we came to know tibia were broken, patella were totally broken. So doctors, the examining doctor, attending doctor, and orthopedic suggested him surgical intervention and some plating on the patella region, right? It was well accepted. I said, okay, fine. We'll go through the surgery. We'll be putting some plating and some wire. And after wiring, you'll be fine. And 1.5 months, you'll be back to your normal life. Okay, consented. Consent was signed. Everything was done. Procedure completed. Plating was done. And the right leg was put on cast. And the time was discharge. Discharge summary was made. There were some red flags in that discharge summary. Some warning signs were there. The follow-ups were there, which the doctor was supposed to mention and tell to the attendant and the patient very clearly, which was missed. What could be it could be some bad side effects of this operation or surgical intervention, which was duly not explained to the patient, and patient was discharged with the cast, right? After 24 hours, that patient called up the doctor, the concerned hospital, and says, I'm having some kind of numbness in my legs and my toes are not moving. Those are senseless. So after 3 days, again, he called to the follow-up to the orthopedic. Orthopedic checked it and said, okay, fine, sometimes it happens, you're on the cast and so post-operation. Don't worry, it will be fine. You just move your toes, fingers, and do some tapping and all, you'll be fine. Went back. So the cast was supposed to remove after 1.5 months, right? 6 weeks time, as usual, which is there. So again, after 1 week, 1.5 week, he called up and he said, no, I have some problem and I have some numbness and no sensation on my leg. This time the term has been changed, no sensation on my right leg. Went to the hospital, orthopedic check. Okay, fine, no worries, you come, we'll remove the cast and you'll be fine, you'll be better. After 1.5 months, he visited to the hospital with lot of worry. Cast was removed, but there is no sensation on the right leg. The patient was 40% disabled. Clear? The patient was sadly 40% disabled. The doctor missed something now. Clear? So tell me now whether this doctor will be held accountable, criminally liable or not. Yes, it is. The discharge summary missed certain things. They forgot to tell because nerve was compressed while during the plating. They would have told this could happen certain times during such kind of surgical intervention. This could happen in near future, and it should be duly consented, which was missing, and this was missing in discharge summary in the follow-up also. Doctor gets sued for the criminal liability and for missing something important facts, red flags, warnings in the discharge summary, and that sadly the patient was compensated for the 50 lakh rupees and litigation 50,000 rupees, plus other compensation 80,000 rupees. So for avoiding such kind of a things, we have to clearly mention everything in the discharge summary. Discharge summary should have broadly 6 components: about detail about the patient and about the hospital details and reason for hospitalization and process done, and during process what were the findings, and the condition of the patient while discharge was stable or some other red flags were there, instruction to the family and the patient what post care about, and follow-ups, which is mandatory, which was missed, and it should be duly signed by the officer also and the doctor also. Yeah. Now there are another kind of discharge which is called DAMA or LAMA. LAMA is leave against medical advice and DAMA is discharge against medical. Both are the same thing. Like when this happens, when patient refuses and against the medical advice and wishes to go, so DAMA or LAMA should be duly signed. Very clear statement why the patient is departing against the medical advice. And it should be clear that he or she has life threat. It should be explained in the local language. Signature duly signed by the patient, doctor, and of course witness to safeguard herself. Here next comes about the digital privacy. Everything has been digitized now. So good, so easy, streamless. So we had DP Act. My co-speaker will share most probably this part, and she has prepared that. So I'll skip this part because I know if it has happened and it leaks out, the penalty is about 250 crores. So we should be very careful about if they have in HIS, hospital information system, if they have given some admin ID password to us, we have to keep it secret to us, and we are not supposed to share it to anybody else. That is in the form of OTP or password, whatever it means. Our authority should not be shared with anybody. Medico-legal cases and VNSS protocols. Now, if we see the classification, broadly classified into 3 portions of medico-legal cases. One is trauma and accident, then one is poison and self-harm, and third one is unexplained demise. Trauma and accident, it could be like road accidents, industrial events, severe falls showing fractures and physical trauma presenting in EAR. Poisons and self-harm, it could be snake biting and suspected poison, homicidal assault, burn cases, or attempted suicide. Unexplained demises, patient brought death to the hospital, the ER, sudden unexplained clinical death within 24 hours of the admission. Clinical procedure and inquest. Inquest word is again a very common word, and everybody heard about that. Where there is any unnatural death. So this is an official process that tries to know and get the information how this death has happened, how that particular person has died. That is inquest. Recently, I was having trial of one murder case. There was a mob, cross-firing was there, and sadly one labor was died. So they was having the bullet goes across the chest. the size of the hole, bullet, cartridge, everything is a part of the inquest to check, to get the forensic, to help the forensic too. This has been, if the police inquest is making by the police, and it is covered under 194 BNSS. If magisterial inquest, it is covered under 196 BNSS. Tusha case is very popular these days. If you have read the Supreme Court order judgment recently, they have ordered the second autopsy, second postmortem of Tusha cases to miss the strangulation or whatever mark was there in the neck. So that is magisterial inquest. Now, emergency MLC handling protocols. So emergency ER management, what we have to do, again, is just I mentioned that we have to stabilize the patient first. First is stabilize the patient, see what is the patient's requirements, how to save the patient. Then identify the case. You find any suspect, is this MLC, whatever marker is there, you have to identify the case. If it is MLC, then send the formal written information to the local police station with statutory limit provided. Then chain of custody, whatever files you have made, toxicological samples you have collected, clothing or whatever it may be samples, you have to secure them under the lock to maintain the chain of custody. Now, forensic medicine. Forensic autopsy checklist I have written over there. For autopsies in medico-legal scenario are regulated strictly to maintain the integrity of evidence for trial under BNSS 194 and 196, which is studied about. Autopsy must not be performed without any legal authorization from police or magistrate of the particular jurisdiction. Family consent is not required. That can be waived off. It is not mandatory. Custodial death autopsies must be initiated and handled on priority within 24 hours of the death. Now, BSA for collecting evidence updates rule of forensic admissibility, heavily emphasizes electronic chain of custody. A break in the chain of custody, such an unsealed toxicological sample, delay in police dispatch, can render vital significant evidence inadmissible in the court, resulting in the acquittal of the accused party. Here, what happens? There was a snake bite case. The girlfriend hired once a pair and bitten her boyfriend on exactly with two fangs on the lower thigh bone, and in resultant he died on the spot. Right now, fangs were there, viscera was collected, sent to the hospital for the sampling. After 6 months, the medicos gave the reports of those viscera, and they couldn't locate the venom in the viscera. That is a sad part, leading to the acquittal. So we should avoid this thing. There is medico-legal decision case. Let's discuss one more case over there. A patient is admitted in a coma state with suspected organophosphate poisoning. The family strongly objects to registering on MLC. Said ki nahi, no, we don't have to do it on, or informing the police, claiming accidental domestic ingestion this way or that way has been ingested and so and so, and fear of social stigma. Normally it happens. It's majorly commonly it happens. Now the operational questions here comes is, can the doctor honor the family privacy request? Is there anyone can answer me? Can the doctor honor the family privacy request in such situation if somebody has ingested the organophosphate poisoning? Ingested? Yeah.
We are getting the response as no.
Okay.
Police has to be informed.
Yes. What is statutory liability under BNS for failing to inform? Duty. This is a bond and duty, legally bonded duty to inform the authority. Right. Now, doctor police interface, validate IDs, receipt mandate, no originals. We are not supposed to hand over original imaging films like MRI, CT, or whatever it may be to the police authority. You have to seek formal order or the judgment or the order from the court. Now there is evidence standards. Section 39 BSA, expert opinion. Medical evidence is corroborative, serving as guidance for the court. Opinion must be objective, logical, and backed by accepted literature. If you get the subpoena is kind of a summon from the court, must follow strict protocols when appearing as witness. You have to be very watchful when you are appearing as a witness or medico. Review the medical records thoroughly before entering the stand. Standing means before answering your question during the witness or the evidence, you have to review the medical records. State clinical facts clearly without speculating on documented details. We are no judge. We just have to say whatever it is there or whatever it has been recorded. Utilize hybrid virtual court options if permitted by a court. It will be safe and sound for you guys. Now comes the confidentiality, privacy, and digital health. A patient's right to medical privacy is a fundamental right covered under Article 21 of Indian Constitution. Physician must safeguard patient secrets. Unauthorized sharing can result in clinical license suspension or civil liability. Breaching patient privacy can expose a practitioner to substantial damages in the civil court lawsuit. There are some exceptions also there. Court mandates. If court is saying, requesting, issuing in very clear legal subpoena or the someone demanding disclosure of the specific patient files and all, then we have to. In the interest of public, when any communicable disease is there like TB, cholera, or whatever municipal bodies, we are liable to inform them. And if there is an active trial for any psychiatric patient reveals a credible imminent threat to family, local area, or wherever, then we have to disclose. Now, social media. So social media is a platform. We like being impulsive. We try to, in the comment section, when we are discussing some case, we have some major images, we try to post it. We should avoid that. There are very clear NMC guidelines about the patient privacy. We cannot compromise that. No photos, never publish wound profiles, surgical records, or scans without clear revocable patient consent. If patient has consented, yeah, of course. Avoid giving specific therapeutic advice or prescribing an open public forum. You cannot go for group diagnosing. No self-promotion. You can, one thing is there, we lawyers and doctors are not advisable for the self-promotion. We cannot add or ourselves. We can write what we have done, a degree and everything. We can attach ourselves with some hospital or some law firm, but we cannot promote ourselves for business purpose. Telemedicine. Oh, wonderful. That's really very wonderful part. It's a word, total word is tele. Total word is IT. It's all on the screen. So teleconsultation is very, very popular these days. So telemedicine practice guidelines 2020 has been issued by the governing body. Telemedicine practice guidelines is for issued by Ministry of Health and Family Welfare. They provided guidelines that provide a legal framework for the RMPs, right? Some standards which we are supposed to follow as RMPs. Medicines can be prescribed through telemedicine are strictly categorized into 4 operational lists under telemedicine practice guideline. List O, List A, List B, and red one is prohibited list. What does List O say? List O is the safe for any remote mode, whether you are consulting through audio, visual, or text like chatting, on first consultation. Examples, you can prescribe paracetamol, ORS, cough lozenges, Strepta. On the text also, chat also you can prescribe, but very safe. List A, which is first video, if you are consulting through video in teleconsultation, relatively safe drug permissible during the first video consultation for common clinical issues. Topical agents apply for the application. Some vitamins are there. List B covers follow-ups. Follow-ups is prescribed during follow-ups only subsequent to the initial, if you think, you can call in-person consultation or the structured teleconsultation for the same issue. Now comes a prohibited list. strictly no list. You can never ever prescribe via medicine, which includes Schedule X drugs and NDPS Act. NDPS drug, which is clearly mentioned in the NDPS Act 1985. We should avoid that. We should never ever. Now, teleconsultancy is done everything. We have to we have a right to get it reimbursed. Yes, you can get reimbursed this telemedication services. Teleconsultation, Ayushman Bharat is covering. Some private insurer have also started covering. No uniform regulatory mandates is there. Mobile eco healthcare system is there. You get the reimburse for the teleconsultation and this whatever they are prescribing telemedicine. You can get the reimburse through your insurer. Complete quick fire quiz. Again, one interactive session is there. So there is one scenario. A doctor posts a blood X-ray online. Is it compliant? Anyone? A doctor posts a blood X-ray online. Is it compliant?
I think it will be compliant till the time it is anonymous and the patient details are not revealed.
Okay. Then scenario B is prescribing psychiatric drugs over video call. Is it legal? Is it legal? I just described this, prescribing psychiatric drugs.
Yeah, getting the response as no.
Oh, thank you so much. That's wonderful. Scenario C, a police officer requests medical records via email. Is it secure?
I
Why?
think no.
It is yes.
Oh,
I did. There is a signed digital requisition from the authorized officer. You can, because see, we have moved advanced. We are into IT now. So somehow this is yes. Let's move ahead. Consent communication and dispute prevention. The consent, the entire consentant, my friend will be covering this. And she's really good at that. So I'm leaving it to her. The next is the consent law. Again, she'll be covering this part. Let's skip this. Now, advanced practices. Video consent standards. Yes, again, the video consent is a part of consent only. Yes, you have to take the consent. You have to record this mandatory. It is there. Video consent means you have to record. You have to video record everything to safeguard yourself. The kind of consent. The power of patient dialogue. It's a relationship between doctor and patient. Open dialogue, active listening, listen to him or her, the patient, and you have to speak in local language. The patient is not able to understand your language. And you have to document the dialogue between you. To shield or safeguard yourself. Risk mitigation, indemnity, and defense. How to reduce the risk. Okay, risk reduction. There is a surgical checklist, there is adverse order, the continuous training. The continuous training is, I guess, as per me, as I think, my opinion, my perspective, that is the most important part. We have to provide regular training for the nurses, administrative staff on legal boundaries, consent, and patient privacy to safeguard. Now, professional indemnity insurance. We medicals, yeah, yes, we are also insured. We get the insurance. Because we have, while buying the insurance, with getting the insurance, we have to keep something check. Ratio focus should be AOY or AOP, 1-to-1 limit ratio. Or we have to see the policy which is giving you out of court coverage also. Confirm the policy covers negotiation settlement, which happens usually out of the court. This we should see before seeking the insurance from the company. Now this handling violent patient. Every day, almost every alternate day, we see some reel, we see some video. The attendant of the patient is abusing the doctor, and a mob is attacking tied to the doctor. We have to safeguard vandalism and physical violence inside the medical establishment. It is growing. It's a growing thread. Every day it is happening. So how we medical professional must act legally and defensively. First, we should try the verbal de-escalation. We have to cool the situation down. We have to say, yes, I understand your frustration. Yes, I do understand. I'm with you. I'm human. I tried my best. I did my duty. So bring the aggression little down, right? And escape. We will not look for the physical path with exit door, which is blocked. We have to look for the open door if we have to escape, really. Then SOP alert is there. We have to look for some panic button under the table or some area, reachable area, we can just to save ourselves in such situation. NMC 2023 state protection laws are there, right to refuse care. Now, if we see because of the attendant behavior or because of patient behavior, we can say no. Under certain circumstances, we can say no, and we can institute FIR too for the hospital assault because this is cognizable and non-bailable offense. Now, legal defense, responding to legal actions. Do's, I guess, everybody must aware of. I'll come to the don'ts. Never ever ignore any subpoena, any notice, any summon, which can lead to ex parte one-sided. Should be very unfavorable. We have to reply. We should not modify any chart. No alteration, no pen, no erase, nothing, no scribbling, no whitener, nothing. And we should not try to reply our own. We should seek legal advice before replying any notice. And we should prohibit ourselves to share everything, avoid it openly on a public hospital channels. Check your method case I just discussed. And thank you so much for your kind time. That's all. I hope you must have learned something, and I had a wonderful time with you. And thank you, Garrick. Thank you so much. Over to you, Garrick.
Thank you, ma'am. That was actually quite insightful. And currently, I'm also a third year medical student, so these are something which I can also closely relate to in the forensic medicine.
Okay.
Yeah. So thank you so much, ma'am. Uh,
Okay.
we we now go back to the fundamentals because understanding the legal framework from the ground up is what makes what advocate Seema ma'am just shared truly actionable. So our second speaker brings a deep expertise in consultation, administrative, and cyber law. She is the advocate at the High Court of Uttarakhand, holds a BLLB and LLM in constitutional and administrative law and diploma in the cyber law. She will walk us through the basics of fundamental jurisprudence and consent in medical practice. Please welcome Advocate Anmol Sandhu.
Hello,
Hello, ma'am.
good evening,
Good evening,
everyone.
ma'am.
Thank you for the warmest welcome. Apparently, it's very cold here today, so much needed warm welcome and dedication. Thank you so much.
Thank you,
And
ma'am.
just give me a minute to connect my presentation.
Sure, ma'am. Ask please.
Hello. Greg, can you hear me, Greg?
Yes, ma'am, you're audible.
Yeah, the Anmol ma'am is facing some problem to connect with her PPT. Can you
Uh,
guide on chat?
yeah, sure. Ma'am, there will be a share screen button at the bottom.
Hanji.
Uh, you can click on that,
Okay.
and then the options will come as to which screen you want to share or which window you want to share. You can select the specification, like for example, the entire screen or just the PowerPoint presentation. Yes, ma'am, your screen is visible now.
Apparently, it's showing unsupported document.
Uh, shall I share the document, ma'am? Otherwise,
Yes, please do so.
uh, just a second, ma'am. I'll just get the document here. Guys, please hold on a second. Actually, there's some technical issues. We are just sharing the screen. Please hold on a minute. Ma'am, is the screen visible now?
Thank you so much, Guru.
Thank you, ma'am.
Thank you, everyone, for your patience. Once again, thank you so much, guys, for your patience and warm welcome.
Thank you, ma'am.
My as my learned friend already has completed the most important part of today's session, I will be completing a very easy draft. So I will start now with the medical jurisprudence. Being so vast and interesting, we will now be discussing duties and legal responsibilities of doctors, along with doctor-patient relationships and law, consent in medical practice, which is very important, medical negligence and legal liabilities, along with some landmark cases. Now, first, legal jurisprudence is an application of medical and scientific knowledge to legal problems, assisting court of law, investigators, and legislatures, as earlier has been explained by my learned friend. The assisting the courts of law, investigators, and legislators in the matters regarding human health, injury, and death. Regarding the historical roots, as everyone is aware, that with the Charak Samhita and Sushruta Samhita, the ethical duties of the physician has been laid down. And with the colonial era, which explained the Indian Penal Code, uh, which actually introduced the criminal liability of medical acts. It has been now it's replaced with the Bharatiya Nyaya Samhita (BNS) via 2023. BNSs and BSA. That is Bharatiya Nyaya Samhita, Bharatiya Nyaya Suraksha Samhita, and Bharatiya uh, BSA. That is Indian Evidence Act. Apparently, we know. So carrying on with the duties and legal responsibilities. Duties and legal responsibilities of the doctor. Here we have divided the duties as such: the duty of care, duty of to obtain consent, duty of confidentiality, duty to treat emergencies, MLC documentation, which has already been explained by my learned friend, duty not to abandon patients. Duty to care, which is that once a doctor-patient relationship has been established, the doctor must treat with reasonable skill and care, obviously. They cannot refuse the established patient without adequate notice. A doctor refusing an established patient without adequate notice does not actually amount to criminal punishment, but rather a disciplinary action governed by the NMC. Violating these professional conduct guidelines can result in a medical license suspension ranging up to 3 months up to 3 years. There are some exceptions that a doctor may immediately refuse treatment if a patient or a relative of a patient exhibit abuse or violent behavior. Even in such circumstances, a report must be presented by the doctor explaining that behavior and provide a proper referral for a patient to seek care elsewhere, as it should be a courtesy. Now, the duty to obtain consent, which is very important, and I will be covering along with my other slides also, Girish. Uh, Duty to obtain consent with my slide number 34, explaining the case law. Am I audible?
Yes, Anmol,
Yes,
ma'am,
ma'am, you're audible. Actually, I unmuted my other device by mistake. Sorry.
Oh, oh.
you are.
Duty to obtain consent. Here, consent is a voluntary agreement of a patient with full understanding to undergo a particular treatment or procedure with the doctor. Without valid consent, any medical act may constitute assault in law. Now, here, acting without valid consent generally strips the medical practitioner of legal protection normally afforded to them. For example, if death is caused by medical negligence without valid consent, then under Section 106, subclause 1 of DNS, punishment of imprisonment for up to 2 years and a mandatory fine may be the doctor may be implicated with such punishment. Here, I will give the examples with the slide number 32. Girish, thank you so much for your help. Thank you, Girish, for assisting me with
Slide
my
232.
PPT. Yes. Slide number 32. Here it is explained.
Yeah. I'm sorry, actually, I cannot see the slide.
It's okay.
Like,
You can go to last ones. I will tell you to stop.
yeah,
The case laws,
yeah.
case laws, landmark judgments. It's
Uh,
A.H. Khodwa versus State of Maharashtra. The next one. Next one. Again, thank you for being so patient, guys. Uh,
no worries, ma'am.
it's state of Maharashtra. A.H. Khodwa
Uh,
versus State of Maharashtra. Yes,
yeah, I got it, ma'am.
yes.
Yes.
Thank you so much. Now here it's explained that the facts and background of this case is the Supreme Court they give the judgment in around 1996, where a mop was left inside the abdomen of a patient during a sterilization operation. The patient developed the certain complication and died, unfortunately. The state argued the surgeon was not negligent as it was a simple error. Now, issue arises: does leaving a foreign body in the abdomen constitute negligence? Can anybody tell me without reading the answers, please?
We are getting the response as yes.
Yes.
That,
Now,
yeah.
the apex court held that with the doctrine of res ipsa loquitur, the first time this doctrine was used in the case for a medical legal case, the doctrine of res ipsa loquitur says the thing speaks for itself. So it was applied for this case, that it applies that medical negligence case where the fact was self-evident. Leaving a mop in the abdomen is a prima facie evidence of negligence. So no further proof was required for the patient. It was the first case to clearly apply this doctrine in medical negligence, that the shifting the burden of proof to the doctor in self-evident cases. It is the very prime example of medical negligence, guys. Now shifting towards the consent, earlier my learned friend already explained one such case of Samira Kohli versus Dr. Prabha Manchanda. Here, acting without valid consent generally does not give the protection to the medical practitioner which they are normally given. If injury or hurt is caused without valid consent, the practitioner cannot claim the general exceptions for good faith medical procedure. They are instead treated similarly to anyone causing harm under the general provisions of law for hurt or grievous hurt, that is section 115 up to 121 of BNS. The punishment for such cases, depending on the severity of the injury, the imprisonment can range up to from 1 year to 10 years plus fine. Here, some protections and remedies are given to the doctors, that is exceptions under section 30 of BNS, where a medical practitioner is completely protected from criminal liability if an emergency medical procedure is done in good faith for patient's benefit without consent. And even in that, if the condition is if obtaining consent is impossible. And how can it be impossible? Can anyone give me the response? Where can a condition arises? What condition can arise where you cannot obtain a consent from a patient?
We are getting the response as
Yes,
unconscious patient
yes.
on the OT table,
Anything else?
a patient, comatose patient.
Yes. Okay. Now it's right that if a patient is incapable of giving the consent, and if, yes, we can call the relatives. If the guardian is not available in time, then such exception works that without getting their consent, the medical practitioner is protected from criminal liability. Thank you so much for such a good response, guys. Now, carrying on, the duty of confidentiality. The patient information must not be disclosed without consent, except now here, see, there is a law and there is a remedy. Both work side by side. The patient information must not be disclosed without consent, except when required by law, courts, public health emergencies, or to prevent harm to others, like to save the society. Even in the general cases like Gunda Act, people the law states that a certain person, if he is harming the society, must be exiled for 6 months from that community to safeguard the society. So that's how it works. Now, here in the duty of confidentiality, there is no specific criminal provision dedicated solely to breaching doctor patient confidentiality. Instead, a confidentiality breach primarily violates civil law and professional ethics and governed largely by NMC and consumer protection laws, such as now, please, Girish, slide to slide number 30 and 35, please. 33, if you may.
Sure, ma'am, absolutely.
The consumer protection laws regarding this case strictly plays a role regarding the consumer protection law.
Ma'am,
Just
which
give me a
case is
minute.
it? I'm sorry.
Yes, yes, I will help you. Just give me a minute. Don't worry. Just a minute. Huh? I
Absolutely,
got,
ma'am, no worries.
I got. So, the duty of confidentiality. Again, thank you so much, guys, for your patience and such a glitch. You're being very patient with me. I will be explaining the duty of confidentiality. There is no specific criminal provision. However, there is a civil law, there is a professional ethics and governed by NMC, and there is a protection covered by the consumer protection laws. Now, here is one law, case law which is covered under consumer protection. That is Indian Medical Association versus VP Shantha. Indian Medical Association versus VP Shantha. It was the apex court of three-judge bench, 1995. The facts were the Indian Medical Association contended that the medical professionals are not covered under the Consumer Protection Act 1986. The doctor-patient relationship is not a service under the act. Now, here is the issue. Are the medical services enable to the Consumer Protection Act? This was the serious discussion of that time. Now, what do you think now in this current scenario? What do you think? Can it be considered service if you apply the mind of those medico-legal jurors of that time? What do you think, guys? Is anyone interested in responding to this question?
We are getting the response as yes.
Okay. So,
Uh,
without wasting any more time, are the medical service amenable to the Consumer Protection Act? Now, in this case, it was held that medical services rendered for charges are services under the CPA Consumer Protection Act 1986, Section 2, Subclause 1, Subclause 0. Now, doctors and hospitals can be held liable for deficiency in service. Free service at government hospital excluded, services under contract for personal service also excluded. Now, the significance here was that open consumer forum to the patients uh, helped in last scenario. Single largest driver of medical negligence litigation in India was the consumer protection, consumer forum. See here, now the next case.
Yes.
Next case was the V. Kishan Rao versus Nikhil Super Speciality Hospital, 2010. V. Kishan Rao versus Nikhil Super Speciality Hospital, 2010. Here, the patient's wife died from cerebral malaria. The husband alleged wrong diagnosis, treated for typhoid instead of malaria despite positive blood test. The NCDRC dismissed the complaint citing no expert evidence. Here, it was held that expert evidence is not always required to prove medical negligence. In cases where negligence is apparent from the record, consumer forums can decide on the basis of available evidence. Here, the Supreme Court set aside the NCDRC order and awarded compensation to the victim. Significance of this case was they empowered consumer commissions to decide. It empowered consumer forums and commissions to decide without always requiring independent expert opinion. And it lowered the evidentiary burden for the complainants in straightforward cases. It shifted the burden of proof to the complaints to the accused party. Now here, now we are talking about the civil law, civil wrong, civil law, professional ethics, and consumer protection. We are talking about. So, what can the breach of duty of confidentiality breach primarily leads to? It leads to license suspension. States, medical councils can issue warnings. No, most of the time the question arises, but if the person actually breaches someone's privacy, how can it be dealt with? So the state medical councils can issue warnings. They can suspend them after the warning or without the warning, or they can permanently cancel the doctor's registration. To and I think it's the biggest warning to the comrades, right? So now civil lawsuits, the patient can sue the doctors for emotional distress, loss of dignity, or reputational damage. The breach of privacy is a civil wrong, and it can result in significant financial compensation to the patient. Now, somehow there are some cases similar to these in the Motor Vehicle Act, if I may. Um, Somehow similar, but not similar. Sometimes an accident happens, and there is a arguments going on between the claimant and the accused, and the accused somehow the they are a party of the person who caused that accident, जिनके ऊपर वो they have the liability and the insurance company. So the fight becomes in between the claimant, between the insurance company, and between the person who caused that accident. So it's kind of similar to that, where the significant financial compensation should be given to the claimant, and later on it's decided whether the accused who caused such accident will be paying the compensation to the patient, claimant, or the insurance company, which was held liable with regarding the cases by after a long while of arguments held. See, now in this breach of privacy, uh, apart from this Motor Vehicle Act, if I may, in India, unauthorized disclosure of digital medical records can trigger civil liabilities. as it covers the DPDP Act also. In India, unauthorized disclosure of digital medical records can trigger civil liabilities under Section 43A of IT Act, which allows for compensation to be paid to the affected person. Section 72 IT Act prescribes criminal liability for breaching electronic privacy. Now, here my learned my learned counsel also discussed it a bit. Here, two things are there. One is a compensation, second is the imprisonment and fine, that is a criminal liability. Just regarding the breaching of electronic privacy and breaching of disclosure of digital medical records. For this, insurance and indemnity plays a vital role for as a remedy for the medical practitioners. The insurance and indemnity, this coverage protects the healthcare providers by covering legal defense costs, court fees, lawyers' expenses, and any civil settlements or damage awarded to the patients. Now, we are coming to the duty to treat emergencies. Here, if I may, Grish, duty to treat emergencies.
Sure, ma'am. Yeah, I'll take the slide up.
Doctor cannot refuse emergency treatment. Doctors refusing emergency treatment constitutes to disregarding the fundamental rights of the Constitution, that is the right to emergency medical care. In the Article 21, that is the right to life. Here, the one case which is already discussed by my learned friend, that is Parmanand Katra versus Union of India, which states that what happened in this case law, that Parmanand Katra versus Union of India, that was 1989 by the Supreme Court, one motorcyclist met with a road accident and was refused treatment by a hospital, which directed the attendants to first go to the government hospital for medico-legal formalities, and he died during the delay. I think most of the people are aware regarding this case. We have seen many dramas regarding it also. That somehow it's a drama playing that somebody is injured and they have not follow up the procedure and they're waiting, and unfortunately the patient died. See, now issue arises that can a hospital refuse emergency treatment on medico-legal grounds? Now here the dilemma arises, and the court, apex court, held that every doctor, whether government or private, has a professional obligation to extend his service to protect life, right? On humanitarian basis, we are doing our duty day to day wise, right? So we should not forget that we are humans, right? So the apex court held that uh, despite our professional obligations, we should extend it our services to protect life. No formality, procedural requirement, or medico legal obligation can be ground to deny emergency care. Here, it was the foundation of the Article 21's fundamental right to emergency treatment in India, which is now reflected in Clinical Establishment Act in 2010 and state level directives. Now, the duty to treat emergencies, if the doctor refuses emergency treatment, it may constitute to the disregarding the Constitution of India, sure, but it also constitutes offences under Section 200 of BNS, which was previously 166B of IPC. Now, Section 200 of BNS explicitly criminalizes the refusal or failure of hospital or its in charge to provide immediate medical treatment in emergency situations. Violating this duty is punishable with the imprisonment for up to 1 year, a fine, or both. Now, here we have the remedy of Section 30 of BNS, which provides that legal protection to doctors for medical acts done in good faith without explicit consent, which again plays a vital role during emergencies when a patient cannot consent and delay threatens their life. Section 28 and Section 30 protects doctors during immediate emergencies. However, Section 106 of BNS is a primary provision addressing medical negligence leading to death. Section 125 BNS punishes acts endangering life or personal safety. As I have already explained in the case Paramanand Katra, moving on, the medical authorities and ethics board can suspend and revoke a doctor's license for arbitrary refusal of care. They can only they can legally accept reasons that a doctor may refuse to treat a patient in a non-emergency settings if they lack the specialized expertise needed. Sometimes there are very complication case has arisen, right? But the doctor specializing in that area is not available. So it's not that any layman can perform such treatment, right? So such exceptions are available if a patient or their relatives exhibit severe abuse, violence, or criminal behavior towards the medical staff. They can certainly refuse to treat certain people. Now, in the duties, MLC documentation, which was explicitly explained by my learned friend. The MLC documentation complete accurate MLC register with time, history, finding, and treatment. Legal documents admissible as evidence must notify police of cognizable offences immediately. Here, there was this case I was having uh, regarding the POXO. What happens in certain cases in criminal appeals in the higher judiciary is that certain medical documents are needed in certain areas like rape or POXO or murder, etc., where it is established how the person died, what was the circumstances, was it a direct evidence or was it a circumstantial evidence? Has anybody was there a motive? Even by the medical report you can see whether the motive of such an action, such a crime can be established or not. And the MLC documentations greatly help in that. Now, the duty not to abandon, I think it's clear to everyone, the duty not to abandon on the humanitarian ground also, and by the professional obligations also, that one should not abandon its patient. Uh, a doctor who undertakes a case cannot withdraw without adequate notice to the patient or transfer of care to another qualified. Likewise, in the duty of care, without adequate notice, you cannot withdraw from the treatment of the established patient. Now, here we are coming to the doctor patient relationship. Doctor patient relationship, Girish. Here, the doctor patient relationship is consists of three types of relationship. One, it can be contractual, it can be fiduciary, it can be tortious. Now, contractual, we understand that an implied contract arises between a doctor when a doctor accepts a patient for treatment, creating duties and rights on both sides. It's very important. Creating duties and rights on both sides. Fiduciary is when a patient trusts its doctor, the doctor's expertise and their uh, experience, a trust and confidence has been built. It's a fiduciary kind of relationship of doctor and patient. And the tortious. By tort, it means a civil wrong. Tortious is if a duty of care is breached and harm results, the relationship gives rise to tortious civil liability actionable as negligence. Here, how the relationship is established between the doctor and the patient. A patient seeks in treatment, doctor accepts the case. Duty of care arises, and the mutual obligation. Now, duty of care means the doctor establishes a patient for treatment, and mutual obligations begin where the patient rights right to information and consent, right to confidentiality, right to emergency care, right to access medical records, and right to dignified treatment. Doctors' rights are right to refuse non-emergency cases, right to refer or transfer with notice, right to professional fee, right to legal immunity for good faith acts, and right to withdraw after adequate notices. Now we are coming to the most important part of our session, that is consent. The consent, previously as I explained, that consent is a voluntary agreement of a patient with full understanding to undergo a particular treatment or procedure. And without the valid consent, any medical act may constitute assault in law. Now there are different type of consent. It can be express consent, it can be written or spoken, clearly stated that with written consent for surgical procedure, anesthesia, blood transfusion, HIV testing, most legally defensible. Implied consent, it can be by conduct. Holding out arm for injection, opening mouth for examination, applies to routine low risk acts only. Informed consent. Here it is the most important consent. Informed consent. It's a full disclosure. It's a gold standard. Patient is given complete, comprehensible information about diagnosis, proposed treatment, alternative risk, benefit before agreeing. Now, proxy or surrogate consent. It is a third party consent given by a legal guardian, parent in the case of a minor, or next of kin when the patient lacks capacity. Courts can override if contrary to patient's interest. Emergency consent. It is also a implied consent where a life-threatening scenario occurs where a patient is unconscious and life is in danger. The law implies consent to life-saving treatment, documents fully, and obtain retrospective consent. Loco parentis consent. It's a child protection consent where a child is brought by a non-parent adult. Doctor may treat to prevent harm, and court orders sought for elective procedures. Here, the I will explain the informed consent more thoroughly. There are many elements in the valid informed consent, and it plays the vital role in the legal scenario. The informed consent should be competent, where a patient must have legal and mental capacity to decide, where full information, diagnosis, process, treatment alternatives, risk, and benefits, full disclosures should be given. Comprehension information provided in a language manner the patient understands. Voluntariness. Decision must be free from coercion, fraud, or undue influence. Decision a patient makes explicit choice, accept, refuse, or ask for alternatives. Documentation again. Documentation, the written consent form signed by patient, a witness, and the doctor. Now, legal importance, if we may, the protect this Article 21 right to life, it protects the patient's autonomy. By failure of informed consent may lead to assault or battery in civil law, which may again lead to compensation. in criminal liability possible under section under BNS 2023, it may rise to imprisonment and fine. Consumer court complaints arise from lack of consent. Again, it will rise to compensation. The legal importance of this informed consent is it shields the doctor from negligence claims when properly documented. Again, in the Samaira Kohli versus Prabha Manchanda case, the Supreme Court held that operating beyond the scope of consent is actionable even if the patient benefits. Earlier explained by my learned friend, where one lady goes for her operation, and when the doctor sees that certain things like uterus and ovaries need to be removed, and they did not take explicit informed consent from that patient, it later on led to such judgment where a Supreme Court held that operating beyond the scope of consent is actionable even if the patient benefited. Now, coming to consent in emergencies and special situations. We all know what can be the special situations, right? Unconscious patient, mentally ill or incapacitated patient, HIV or sensitive tests, minor, refused consent or refusal to of treatment where a competent adult may refuse even life-saving treatment, document refusal, counsel patient, obtain written refusal declaration, or sterilization or abortion. It's a MTP Act 2021 amendments. Medical termination of pregnancy Act 2021 amendments, where a written consent from patient essential, spousal or partner consent not a legal requirement for adult women. Coercion is punishable. Again, it's punishable. Criminal liability. Now coming to common consent. Common consent related mistakes. Here, blank or general consent on admission, no. Obtain specific consent for each procedure. General admission consent is not sufficient for surgical or invasive acts. Consent after sedation or anesthesia. Consent must be obtained before any sedative. Post sedation consent is legally invalid. Verbal consent only for major procedures. All surgeries, all surgeries must require written documented consent. Not explaining risks and alternatives. Failure to disclose material risk, even if rare, constitutes a breach of informed consent, which again will lead to criminal liability. Operating beyond consented scope, unless life-threatening emergency arises during surgery, stay within consented scope. Again, with Samaira Kohli case, it was said, even if the patient benefited, you cannot cross your line. Accepting verbal refusal without documentation. Refusal of treatment must also be in writing, signed by patient and witnessed to protect the doctor. See, when we are learning how to drive a car, specifically, I remembered one moment in my life when I was learning how to drive. My driver coach told me only one thing: you only need to protect your own car, not the other car that is in front of you or behind you. So it's also like this: accepting verbal refusal without documentation. You need to protect yourself. The refusal of treatment must also be in writing, signed by patient, and witnessed to protect the doctor. You need to protect your own vehicle, your own uh, vessel. Now, coming to medical negligence and legal liability. Here, again, the medical negligence arises by duty of care where the doctor-patient relationship exists, creating a recognized legal duty to treat with skill and care, breach of their duty, deviation from the standard expected of a reasonably competent doctor in that specialty. Here, the Bolam test is mentioned. The Bolam test was in the case of Jacob Matthew versus State of Punjab. It's a Bolam test is a foreign case law where it was mentioned that a doctor is not negligent if they acted in accordance with a practice accepted as proper by a responsible body of medical professionals with relevant knowledge and experience in that field. See, sometimes some practitioners give some different view, some give different view. So the Boland test it was generally recognized in the Jacob Matthew versus State of Punjab, as explained by my learned friend, that a doctor is not negligent if they have acted in accordance with the practice as accepted by their fellow peers. Now here, what constitutes a medical negligence is the duty of care, breach of duty, and the causation and damage. That breach must directly cause harm or injury, as I earlier explained in the case laws of where a a death was caused by the medical negligence, where a mop was left behind in the abdomen, right? So that caused the actual damage was proven and ultimately it led to criminal liability. Now, what constitutes negligence? Wrong drug or wrong dose causing death, operating on wrong patient on or wrong site, leaving instruments inside a patient post surgery, failure to diagnose based on obvious clinical features, discharging patient prematurely against clinical judgment. Does not constitute what does not constitute negligence. Honest error of clinical judgment in complex cases. Sometimes it happens, right? But everything's fine because it's a minor error. It does not cause any major damage or any damage specifically. Adverse drug reaction despite proper precaution. Proper precaution has been taken, but adverse reaction happens. So it does not constitute negligence. Proper outcome despite following accepted protocol. Failure of experimental or high risk treatment, right? Complications of inherently dangerous procedures. It happens. So it's fine. It's not a negligence. You know already what is gonna happen or what cannot happen, but you have to follow what constitutes negligence and should avoid that. Now here, then criminal negligence consists of civil negligence and criminal negligence. If we follow the legal aspect of the negligence, which ultimately causes a criminal liability, how is it followed? There are certain aspects. First of all, it's a legal forum where a civil negligence or criminal negligence can be handled. Civil court or consumer forum handles civil negligence, which amounts to compensation. Criminal negligence, session courts or criminal courts, which amount to ultimately in certain sanctions, punishments. Standard of proof. Now, the standard of proof, that is a burden of proof, if I may. In the civil negligence, the balance is of probabilities. And in criminal negligence, it's beyond reasonable doubt. Degree of fault. In civil negligence, simple carelessness or lack of skill may cause civil negligence, but in criminal negligence, it should be gross or reckless disregard for life. Outcome. Now, what is the outcome? Again, I have already told that it can be a monetary compensation to the patient, to the civil, and in criminal, it will lead to sanctions, imprisonment, fine, and or registration cancellation. The governing law. In civil negligence, the governing law may be tort law. It is a civil wrong. or Consumer Protection Act 2019. In governing law for criminal negligence, it's Bharatiya Nyaya Suraksha Samhita, formerly Indian Penal Code. Regarding it is now 106. Previously, it was 3048. Key case in the civil negligence. It was a Spring Meadows hospital case. We will come to it later on. And in criminal negligence, it was Jacob Matthews versus State of Punjab, 2005. Here, they have explained in the Jacob Matthews, which is a very landmark judgment of India, a very high degree of carelessness required to establish criminal liability in medical cases. Now, I'm coming to Consumer Protection Act and doctors. Medical service is a consumer right. Consumer Protection Act and medical profession. The Spring Meadow Hospital versus Harjol Ahluwalia, 1998. It's a landmark ruling. Medical services are services under the Consumer Protection Act. Patients are consumers. Hospitals and doctors are liable to consumer court for deficiency of service or negligence. Now here the deficiency of service is an inadequate treatment, failure to diagnose, delayed treatment causing harm. Unfair trade practice, overcharging, unnecessary procedure, false promise of cure or guaranteed outcome. Even in the legal professional, we are told in the first of all that never make false promises of cure or guaranteed outcome unless you are confident enough you can win this matter. So never do that. Unfair trade practice is a simple no either way. Medical negligence, any act or omission falling behind the standard of a reasonably competent doctor. Medical negligence we already know, right? So lack of informed consent, operating without consent again or beyond consented scope may lead to uh, either civil wrong or either criminal liability. What is excluded from this act, Consumer Protection Act? Free services at government hospital, no fee charge. It is excluded from this act. Charitable institutions provide free treatment. Services under contractual employment by the state. Here, the consumer redressal forums are present with their hierarchy of district, state, and national commission. Now, coming to core legislation governing medical practice. Earlier, I already explained the BNS, Section 106, death by negligence, which is punishment up to 2 years for doctors, 5 years for anyone other than doctors. Section 23, it's a core legislation governing medical practice after Consumer Protection. Section 23 is a consent in good faith in BNS, and Section 25, again I will explain. BNS Section 106 is a death by negligence, which is a criminal liability of imprisonment up to 2 years for the doctor and 5 years for any other person. Section 23 is a consent in good faith. It's a remedy for doctors. Section 25, act for benefit of a person without consent in emergency. Section 125 is a hurt, and Section 3, Clause 5 is criminal knowledge. Now, BNSS. BNSS is, it was replaced by Criminal Procedure Code. It's a Bharatiya Nagrik Suraksha Samhita 2023. New MLC and FIR procedure, Section 173. It is a zero FIR, and 176 is inquest, as earlier explained by my learned friend. And Section 194 is postmortem, which again plays a very important role in documentation in the many criminal cases. Audio video recording of dying declaration mandated. Now in BNSS, audio video, earlier it was not, now it's mandated. BSA, Bharatiya Sakshya Adhiniyam. 2023. It replaces Indian Evidence Act, Electronic Records Now Primary Evidence, Section 53 to 63. Medical records, CCTV, e-consent admissible, expert opinion provisions under Section 39 of BS, as earlier explained by my learned friend. Indian Medical Council, 1956, and NMC Act 2020A for registration, disciplinary proceedings, Code of Medical Ethics, Clinical Establishment Act 2010, mandatory registration, minimum standards, display of rates. Consumer Protection Act again, medical services under service definition, state, district, state, and national commission hierarchy. Now coming to additional regulatory framework. Here, Transplantation of Human Organs and Tissue Act 1994, (THOTA), brain death criteria. What it covers is basically brain death criteria, donor consent, authorized transplant centers. It covers that section. Now, Mental Health Care Act 2017. It covers the right of persons with mental illness, advanced directives, informed consent in psychiatry. Again, the consent plays very vital role in the Mental Health Act also. Epidemic Disease Act in 1897, which was amended in 2020. Duties during epidemics, protection of healthcare workers. As we all know, we have all gone through the COVID, so we are already aware of that. Drugs and Cosmetics Act 1940, pharmacovigilance obligations, rational drug use. As earlier explained by my learned counsel in the NDPS Act, where illegal usage of drug or even if its supply or anything, this Drugs and Cosmetics Act also covers that scenario. Biomedical Waste Management Rule to 2016. It consists of segregation, disposal, documentation, obligations of every healthcare facility. Right to Information Act 2005. Medical records are accessible, duty to provide on request within 30 days. Now, with the digitalization, the Right to Information Act, IT Act, is playing a very vital role nowadays. Now, coming to, as my friend has already covered the documentation part, so we will skip it. Now, fundamental patient rights in India. We have covered it already, the right to treatment, informed consent, confidentiality, medical records, patient entitled to copies of all records. See what happens in this. When a certain case arises, there is a need for records and investigation and discharge summaries on request. Right to second opinion. Doctor must not obstruct ethical obligation to facilitate. Even in our legal framework, it happens. Right to second opinion is a must. Right to refuse treatment. A competent adult can refuse any treatment. Refusal must be documented with a signature. Again, previously explained. Now, we know the duty and ethical obligations of the doctor. We have already covered that. Now, landmark cases. Some cases were left behind, so I will cover them here. We know about the Jacob Matthew versus State of Punjab. We know the Spring Matthews. We know Samaira Kohli. Now coming to vicarious liability, V. Krishna Kumar versus State of Tamil Nadu. Now, what happened in this? Vicarious liability is again a tort law. Tort law means civil wrong. Vicarious liability for example, we have a car, we have a driver. We are not present in the car. The driver took a car and a hit and run case happened. See, nobody was injured for see, not to making it any serious, but a hit and run happened, or even if an injury occurred. See, so what happened? Whether the driver is liable. Now here the vicarious liability is who is the car owner. That person is liable for the compensation if any injury has not occurred. Now, huh, so what happened? Negligent treatment at a government hospital led to preventable bilateral blindness. Here, the state is vicariously liable for the acts of its employed doctors. It was a government hospital, right? It was a driver, and the state is the car owner. So liability automatically shifted to state in a vicarious liability, that they are liable for the acts of its employed doctors, that the compensation of such and such was awarded, and the public hospital are not immune from negligible claims. Did everybody understood this case? Please respond in the chat scene if everybody understood this case of B. Krishna Kumar versus state of Tamil Nadu. Okay, thank you so much. Now in the next case, Paschim Banga Khet Mazdoor Samiti versus state of West Bengal. Now what happened here? Right to emergency care. Injured labor denied emergency treatment at multiple government hospitals. Now again, Constitution, Article 21, right to emergency medical care again came out, that state duty to provide medical facilities. Failure is a constitutional violation. Lakshman Balkrishna Joshi versus Trimbak Bapu Godbole, 1969. Here, the standard of care. The doctor treated a fracture without anesthetic. The patient went into shock and died. Now, here the Supreme Court held that a doctor must possess and exercise the standard of a reasonably competent practitioner of their specialty and classic duty of care ruling. More landmark cases. Here was there was this one sexual assault case where a two-finger test ban occurred, Leelaben versus State of Gujarat, where the Supreme Court categorically banned vaginal test and sexual assault case examination. It was held that it violated the survivor's dignity under Section 21. Mohanan versus Prabha G. Nair, Kerala High Court, 2004. Consent and negligence again. The failure to explain risk of surgery and obtain proper informed consent held to constitute negligence. The patient's right to autonomous decision making is legally protected and must be respected by treating physicians. A.S. Mittal versus State of UP, 1989 Supreme Court. Mass negligence, eye camps. Here again, the negligent mass sterilization eye camps caused blindness in hundreds of patients. Supreme Court held state and surgeon both liable. Established that scale or volume of service does not dilute standard of care obligations. Bolam versus Fryan. Now again, see, it is the most important. It's the UK case law, Bolam test as we call it, Bolam versus Fryan Hospital Trust. It was known as a Bolam standard. Though a UK case consistently applied in Indian courts, doctor not negligent if their conduct was in accordance with accepted medical practice of a reasonable body of professionals in that field. If your fellow peer also believes that the way you have treated the patient is the correct way, and they would have also done the same thing. That is the Bolam test. Now, I've covered the Permanent Katara, Indian Medical Association also, Jacob Matthew, A.H. Khudro, most of it has been covered. Coming to Malay Kumar Ganguly versus Sukumar Mukherjee. Here, Supreme Court 2009, Malay Kumar Ganguly versus Sukumar Mukherjee. Patient died from toxi-epidermal necrolysis. 10. A known but rare drug reaction. Doctors were alleged to have failed to diagnose 10 and administered some other drug, right? So here, the liability of doctor for failure to diagnose and treat a rare drug reaction. Here, the Supreme Court held the doctor must be aware of well-documented drug reactions. Failure to diagnose a known documented condition can constitute to negligence. Hospital and individual doctors held jointly and severely liable. Supreme Court has earlier explained by my learned friend of the joint liability. Here, the doctors and the hospital, individual doctors and hospital, both were held jointly liable, and Supreme Court laid down guidelines for trial courts handling medical negligency cases. Significance was clarified hospital vicarious liability. Again, the vicarious liability has been used here. Reinforced duty to keep updated clinical knowledge. SOP for drug reaction management. Now coming to, now the question arises, which these are very concerning for today's scenario, is telemedicine. These are the basic emerging medico-legal challenges in India, right? Telemedicine, new legal framework, liability when the physical examination not done, informed consent via electronic means, artificial intelligence in diagnostics. Who is liable when an AI system misdiagnoses doctor, hospital, or AI vendor? These questions I have not answered. You have to answer these. So you may respond in the section first is telemedicine, new legal framework, liability when physical examination not done, informed consent via electronic means. Any answers? Chalo, we will skip it, or my learned friend may answer as she has explained telemedicine earlier. Ma'am, if you may, telemedicine, new legal framework, liability when physical examination not done.
I think that is a liability.
Right? Hmm. Yeah, correct. To the my fellow peers and doctors. Now, next question is artificial intelligence in diagnosis. Who is liable? Doctor, hospital, or AI vendor?
I think both of them should be at risk.
Now, that's a thought, na? That's the thought to seriously analyze and consider it. Electronic health records, data privacy under DPDP Act, security breach liability, right to data probability. Is anybody answering? See, violence against health work. See, these are the questions I have arised for you to think about after this session. First of all was telemedicine, second was artificial intelligence diagnostics, electronic healthcare EHR as we have started using it, data privacy, DPDP Act, violence against healthcare workers, which is covered in 118 BNS and 132, hurt and grievous hurt with enhanced penalty, state level healthcare personal protection act, BNSS section 173, which enables zero FIR for attacks on doctors, Surrogacy Regulation Act 2021, and Art Act 2021, new legal duties on IVF centers, genetic clinics, and practitioners, and COVID-19 jurisprudence, NDMA and NDMA Act, post treatment orders, EPO in 1897, and liability for hospital acquired infection. These are the certain topics which need to be considered nowadays. So with this, we have covered our takeaways: medical jurisprudence, informed consent, duty of care in emergency care, civil and criminal negligence, MLC documentation, Consumer Protection Act, and emerging issues. A doctor who knows the law can protect both their patients and themselves. With this, thank you so much for your attention and time and patience, a lot of patience actually. Thank you so much.
Uh, Thank you, ma'am. That was actually pretty interesting with all the landmark cases that you included. That was something which actually gave it a pretty nice touch and made actually learning about forensic medicine. This is something like I want to be taught in our schools and in our colleges as well. Like this is something which makes it much more of a practical benefit to us also.
Thank
So
you
yeah.
so much. Happy to help.
Uh,
There is a saying that a doctor or an advocate can never say, हमारे लिए कोई सेवा बताएंगे.
True, ma'am.
Thank
So
you so much.
guys, if you have any questions, you can post it in the chat box also. I think many of you had posted, and Seema ma'am has already covered that. Thank you so much, ma'am, for that. Actually, from like I had one of the question like from your experience, like what is one of the single most common documentation error or documentation mistake that would turn, I would say, a defensible case into a indefensible one. I hope indefensible is the correct word.
Yeah, Girik, this is towards me, I guess, the
Yeah.
question.
Yes.
Yeah, Anmol ma'am can also join me for the same question. We both can answer the same. So I repeated that the stronger defense is not a brilliant argument. This is documentation which you do, the doctor. So the thing is that about the patient details, it should be very proper, very apt. You have to mention each and every detail, signature, the consent signature, the witness. That is very important. The inquest it should be in a very prescribed form and duly filled. If it is not duly filled, then it will go towards defense.
True, ma'am. And like how, and in the case of the Copra Act, like which changed the doctor's liability, do you think the current framework is fair to the doctors? Like initially, uh, like as of now, I think healthcare is something which has not been included in the inclusion list, but has not been also mentioned in the exclusion list. I think that is something which we are also studying in that way. So, do you think the
Anmol ma'am is also there. She covered this protection. Otherwise,
cop-
I think for this act is neither anti-doctor, not anti-patient. This is a kind of, you can say, purpose is to held accountable. If any negligence has done, something went wrong, civil tort she was talking about in detail, then this is just to held accountable. It's not any kind of punitive or the punishment is given. So,
ma'am?
and yes,
Uh,
Anmol, what
Yes,
is your
ma'am.
say about this?
I think you have covered most of it. When my learned friend is giving the guidance, I don't think I need to speak at all. I'm learning also.
I think there is a question in the chat box. To do a medical legal practice, is it required to do LLB or PGD in medical law firm from ILU Bangalore will be sufficient?
Here I'll say something recent, most recent. I'll tell you, here is one citation for that couple of days back or week back. If you want to practice as a lawyer, being medico, you have to get your medical license cancelled first. You cannot.
Hmm.
So sorry.
The next question
You
is
cannot
with
be in both boats. You
Yes, you
cannot have the
cannot
cake
be
and eat
both
it too.
worlds. Yes, you have to choose one.
true. The next question is with the increasing adoption of electronic medical records, how is the authenticity and the chain of custody of MLC medical legal cases documentation being maintained?
Yes, Anmol ma'am.
With the increasing adoption of intellect concept, they may not be maintained. Well, see, um, yeah, in this I will only say that India hasn't fully resolved it. It's a day-to-day work, and the only what will help the younger doctors is they will have to maintain a certain habit of documenting, not on their WhatsApp. First of all, see the
The
how the authenticity and the chain of custody of NOC documentation is maintained. Ji ma'am, you were saying.
No, I was just saying कि otherwise HIS has been advanced. Long back, I think it was somewhere in the 2011 or 12, I did this research in HIC, Hospital Information System. So starting from the computer section to the each and every department and segment I visited when I did this research, and that was duly published. Since then, till now it has been evolved so advanced. That time PAX was just started, Girik. Now we have the DICOMs. So safety is in our hand.
Okay.
Security is everything is in our hand. The way I said that it is up to us how you'll be keeping it safe.
True, ma'am.
As a user, I'm talking about, right?
Yeah. Like still we can see the courtrooms are actually so filled with cases and everything.
So it quite
Eh,
has been used better
We
than
are
before.
actually getting quite adapted in it.
Exactly, Anmol ma'am, exactly true that.
There's another question. To make sure there is no tampering of medical documentation, how can patient protect themselves?
There can be a witness while they're signing their matter. As earlier explained, that there should be a witness present during the documentation and signing. The
Multiple times
patient,
the witness signature is very important.
very, very
So we try to make sure you should have at least three witness signed.
exactly.
Minimum three of them or two of them, not single one. It should not be your relative to anybody over there.
Hmm.
Mm. And the next question. Yeah, sure. Uh, sorry, just a sec. Yeah.
We
No, he
definitely
was
share our
asking.
PPT. Don't worry.
Yeah, the sharing of the PPT for the upcoming DNB FMT exams. For sure. Like if the speakers allow, we will for sure share them. In your experience, what aspect of the MLC documentation is most frequently misunderstood by the clinicians but becomes crucial during cross examination?
Hmm. You can say
So,
in the
yeah, Mona.
hmm,
Okay, like, see, during trials, when chronic cross-examination has been conducted, the doctor, when inquest is there, suppose example, I'm taking the inquest form is it should be duly filled, pictorial diagram should be there, cause of death should be very aptly written, the time is very important.
Mhm.
When incident occur, like there should be no memory gap, right? So if you have done any gap over there, any flaw, even 0.1% flaw is there, so you are
see,
lost.
for example, a patient died such on 12, and it's written on the PMR. It's written the patient has died on 12, and it's written that he has died on 11 or 10 or something like that. And somebody else will come in the court and they said that they saw that a certain person was alive back then.
Exactly. Other way, like sometimes medicals try to scribble, like they are in haste, and maybe it's too late night autopsy is happening or something is happening, 0 and 8 or 6 or 8, there is misunderstanding. Even for the seconds also, then you are missed.
Hmm.
So you have to be very cautious. For
And
And
handwriting.
closely
even
relate.
if
Because we are doing it
coming to the earlier question of that of how the patient can protect themselves, even the same scenario can occur in this only regarding the witnesses. If there is no witness and the patient has signed the document, then there can be a scenario that somebody else will come that this patient was in Tamil Nadu back then and this case was being held in Uttarakhand. He was not present there, and they have the whole proof of that.
Yeah, true
This
that.
can happen. Can happen.
True, हाँ. And close to relate, this is what my HOD also says कि टाइम ठीक से लिखा करो रिपोर्ट पे. तुम लोग पहले का दिन लिख दोगे रिपोर्ट में.
Even for FIR also, this is very crucial.
You know.
Very crucial.
The next question is, can the witness be a hospital worker or it should be a patient's relative only?
Yeah. Over to Anmol now. Too much is happening. See, I have to speak a lot, so I'm blah blah. So,
It depends. I think it should not be an interested witness.
Like a third party witness.
any third party.
Okay. I'm pretty sure our audience has much more question. If you do, you can post it in the WhatsApp group. Also, we'll take it and pass it on to our speakers because like as of now, I think we should wrap up today's session also because we have already taken so much time of our speakers also. And I hope it the session was truly enriching for our audience as well. And actually, this is something which was very unique when the IRC also approached me with this. So like when they reached out to me, I was like, yeah, this is something which needs to be done. And since we are studying it in our college, also we can so closely relate and we can so closely and like the Copra Act that Anmol ma'am also mentioned, like that is one of the most important topics in our university exams, especially for me. And today only I was literally reading the Copra Act in my book. So yeah. So like with
Happy to
that,
help.
we thank you so much. I'll definitely integrate those points in my answer sheet now. थोड़ा HOD के सामने भाव बढ़ जाएगा when I write those landmark cases.
Certainly, certainly.
And like with that, we come to an end to this truly enriching session. And like as truly said, the law and medicine are not separate words. They are very closely related to one another. And as said by speakers, and they intersect every day. In fact, you guys can also see it in the clinical practice. And tonight has made that much more clearer also, I think, for all of us. And a very huge thanks to Seema ma'am, to Anmol ma'am. Thank you so much for giving your precious time to us and actually explaining like in detail. Like and actually, as I said, the landmark cases that Anmol ma'am took, those were, and in fact Seema ma'am also, like that was something which I told like I found very interesting and that something that should be also integrated in the medical textbooks also. So I think that is something which was truly a highlight for today's session.
It's totally our pleasure. Totally our.
Thank you, ma'am. Guys, you can fill out the post-event form also in the, which is posted in the chat box, and the certificates will also be sent out. The link is active only for 30 minutes. And if you do wish to connect with our speakers, you can always reach them out over LinkedIn. And if you have any questions for speakers, you can post it to us on the WhatsApp, and we'll truly forward it to them and get back to you as soon as possible.
Thank you. Thank you, everybody. Thank you so
Thank you
much.
so much. Thank you so
Thank you so
much.
much, ma'am. Thank you, guys. Thank you, everyone. And a very good evening to all.